Good afternoon, everyone. My name is Karen Greenberg, the director here at the Center on National Security at Fordham Law, and I'd like to welcome you to today's panel on crimes of aggression, crimes against humanity, and war crimes in Ukraine with our guests, OONA HATHAWAY and GABOR RONA. So much has happened in the 3 weeks since the Russian invasion of Ukraine, and among the many things that have occurred, the legal conversation and legal efforts have taken on an urgency and an importance that seems to mount with each passing day. President Biden and Secretary of State Blinken have called Putin a war criminal. The US Senate has called for an investigation into Putin's war crimes and crimes against humanity in Ukraine. There have been calls as well for the creation of a special tribunal to determine whether the Russian invasion of Ukraine has been a crime of aggression. There have been calls for prosecution of war crimes and crimes against humanity at the ICC, and the ICJ has ordered Russia to halt military operations. In quite profound ways, then, we are seeing the confrontation between brute force and the rule of law, something that those of us who study the war on terror have been witnessing in other forms for decades now. What role can law play? How powerful of the laws and institutions we've created are able to prevent war, carnage, suffering, and other things that we have seen for the past 3 weeks now? To help us look into this, we have two guests who have been thinking about these questions in historical and contemporary context throughout their careers. GABOR RONA, a longtime friend of the center, both here and formerly at NYU, is professor of practice at Cardozo Law School and a lecturer in law at Columbia Law School. GABOR was previously the International Legal Director at Human Rights First, and before that, legal advisor at the ICRC. And you can find much of his writings on just security and opinio juris. He has also written many scholarly articles relevant to the war on terror. And one in particular I want to mention, A Bull in the China Shop, The War on Terror and International Law in the United States, which I recommend and which I particularly like. OONA HATHAWAY, new to CNS, is the Gerard C. and Bernard Latrobe Smith Professor of International Law at Yale Law School, Professor of International Law and Area of Studies at Yale's Macmillan Center, as well as a professor in Yale's Department of Political Science and director of the Law School's Center for Global Legal Challenges. She is also an executive editor at Just Security. OONA has been a member of the Advisory Committee on International Law for the Legal Advisor at the State Department since 2005, and she is the author with Scott Shapiro of The Internationalist, How a Radical Plan to Outlaw War Remade the World. GABOR, OONA and I will talk for a little more than half an hour, and then we're going to take your questions. So please feel free to put them into the Q&A, and we'll get to as many as we can, either during the conversation or in that last half of the event. So let's start with you, OONA. You've written these past weeks in a variety of formats about a full range of crimes attendant to this invasion, from war crimes to crimes against humanity to crimes of aggression. But I'd like to focus here, for starters, on the UN Charter and the crime of aggression. Russia's tried to spin this war as a war started by Ukraine, but the fact remains that this was an act of unprovoked Russian aggression. Can you talk about the crime of aggression, what it is, what are the remedies, what are the repercussions potentially once these violations have been carried out? And what's the difference now between Russia's annexation of Crimea and what's happening now, and perhaps even the involvement in Syria? How do we understand, is it a magnitude of difference? What is the legal difference here?
Yeah, thank you so much. Thanks so much for having me. It's a real pleasure to be here for this conversation. So I think it's important when we're talking about the war in Ukraine to separate kind of two bodies of law because the remedies for the two different bodies of law are different. So one is the law that governs when it's lawful to resort to force. Lawyers refer to this as the jus ad bellum. This is Article 2.4 of the UN Charter, which prohibits states from resorting to use of force. And this is the central rule of the international legal order that the Russians are violating. That is a rule that's enforced criminally through the crime of aggression. So if a state invades a state in violation of Article 2.4 of the UN Charter, the criminal remedy for that is the crime of aggression. And we can talk about kind of various ways in which that will be the various ways in which that might be prosecuted. Then the second body of law is a law that says, once you're in war, what are the rules that govern what you can do? This is sometimes referred to as the jus in bello, or international humanitarian law, or the law of war. These are all, or law of armed conflict. Those are all different names for the same thing. And this is a body of law that, as I said, governs what states can do once they're in conflict. So one of the key principles of the jus in bello is the prohibition on targeting civilians, for instance. And when there are serious violations of jus in bello, of international humanitarian law, those can be prosecuted as war crimes. So those are kind of the two bodies of law. Now, you asked about the crime of aggression. We're also going to find that there's different fora for these two. And part of the reason for that is that the crime of aggression can only be prosecuted in the International Criminal Court against states or against individuals who are citizens of states that have joined the charter, the Rome Statute. Russia has not joined the Rome Statute, nor has Ukraine. Ukraine has submitted the matter of the conflict in Ukraine to the International Criminal Court, but unfortunately, that doesn't give the International Criminal Court jurisdiction over the crime of aggression because of the various kind of funny jurisdictional rules of the Rome Statute, which only allows the crime of aggression to be prosecuted against states that are party to the Rome Statute. So for that to go ahead, there would have to be a separate new special tribunal set up to prosecute the crime of aggression. And that's why you hear some talk about setting up a hybrid tribunal or tribunal under the auspices of the General Assembly or some other way to prosecute this crime of aggression.
Thank you for that. There's a piece yesterday and I think today, first it was I think it was in the Washington Post actually today, with a model indictment for the crime of aggression in Ukraine. Did you look at that?
Yeah.
And they invoked the Rome Statute and the ICC. And so can you explain a little bit how this can happen even without Ukraine being a signatory and just how this might play out? Because although they talk about the actual indictment, the sense of how this would actually work, and is this just a sort of clarion call for what the issues are, or is there some bite to this?
Yeah, I mean, I think there is possibly some bite to it. So as I mentioned, Ukraine has submitted events in Ukraine since 2013 to the International Criminal Court, even though it's not a party to the Rome Statute. So states can do that. They can agree sort of for special purposes to submit to the Rome Statute. But as I said, that doesn't cover the crime of aggression, which is one of the 4 crimes that ordinarily can be prosecuted under the Rome Statute, but it has a more limited jurisdictional scope. And so one of the challenges, if you're not within the Rome Statute, is that the crime of aggression, we have a kind of intuitive sense of what it means. It means essentially engaging in acts prosecuting an illegal war, that is a war that's being waged in violation of Article 2.4 of the UN Charter, which manifestly, as you said in the outset, is clear in this case. It's clear that that Russia doesn't have any legal basis for its decision to wage war in Ukraine. Putin tried to make some arguments about how he was acting to prevent a genocide. The International Court of Justice shut that down by saying, no, there is no genocide going on. And, that wouldn't justify the resort to force. So that's why the International Court of Justice opinion is an important one, because it kind of shuts down that argument, which I think everyone saw as kind of clearly, unjustifiable, but nonetheless, it helps a lot to have an international court, and particularly the International Court of Justice, call it that. And Putin also kind of tried to argue that there was a kind of collective self-defense justification, that he could declare these independent regions of Ukraine independent, and they could ask for him to come in, and that would somehow make it legal. And that also doesn't work. There is an idea of collective self-defense, but that only works if it's an independent sovereign nation seeking the support of a state. Those regions of Ukraine are not independent sovereign nations. They can't seek the support of Russia to intervene in Ukraine, which is an independent sovereign nation. So it's clear that there is an Article 2.4 violation, or it's pretty manifest that that's taking the place. So when that's true, then it turns to the question of, how can we prosecute this crime of aggression? Now, listeners are probably familiar with the Nuremberg Tribunal, which was set up after World War II, where the crime of aggression was prosecuted. Now, that was created after the war, or in the midst of the war, it was stood up, and it didn't pre-exist the conflict. And that was set up specifically to try the Germans who had been responsible for an illegal war. People don't tend to remember that the crime of aggression was a key part of that prosecution. In fact, it was in many ways a legal linchpin for getting the prosecution going. The Holocaust crimes were obviously a significant part of what was prosecuted there, but you needed the crime of aggression to kind of get the Nuremberg trial going. And there, what they were prosecuted for was waging a war in violation not of Article 2.4, because Article 2.4 didn't exist yet, but of waging a war in violation of the Kelly-Briand Pact, which also outlawed war. Was the 1928 decision, a treaty that most nations of the world joined that prohibited use of force. Germany had joined that treaty, as had Japan, despite the fact that they, and Italy, despite the fact that they then waged an illegal war. And so they were prosecuted for the crime of aggression because war had already been outlawed. So you don't need the UN Charter necessarily to get it up and going. But there are specific jurisdictional constraints to the crime of aggression under the International Criminal Court. There's also a specific definition of the crime of aggression under the International Court, but you don't necessarily need to be stuck with those if you're no longer in the International Criminal Courts. You're not prosecuting the crime in the International Criminal Court. So the crime of aggression in the International Criminal Court requires a manifest violation of the UN Charter. I think it probably, any likelihood of this being prosecuted is going to mirror very much that language, and is probably going to adopt a lot of the definition from the International Criminal Court, but it doesn't necessarily have to do so. And again, I think there's this question of where is it going to happen and how's it going to be stood up? It can't be done through the Security Council because Russia will obviously veto that. So the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda were stood up by the Security Council. That's not going to happen here. And so there's a question of kind of what are the mechanisms by which it's going to be set up in the General Assembly, given that you had the vast majority of nations vote to condemn the Russian invasion as in violation of the UN Charter, seems like a really good place to start.
Yeah, I wanted to just touch on something related to this, which is that you've been writing about outcasting. I think you had a recent piece in Foreign Affairs as sort of what you think is in the bag of possibilities of how to respond in a way that would matter to this war. And I just wanted you to talk about, because you have kind of an expansive definition of outcasting, talk about that and why you think it's important. Is it because it helps the legal case, sort of builds a kind of momentum? Is it, explain it. I'm trying to put words in your mouth. Yeah,
no, thanks for asking that question. So this draws on work that I've done together with Scott Shapiro. We wrote an article called Outcasting, where we define this. And then we wrote a follow-on book where we developed the argument more fully and kind of contextualize it, called The Internationalists. And the argument is that, sometimes people object to international law as not being enforced because they say, look, we don't have anything that looks like police. We don't have a court with compulsory jurisdiction. We don't have like the things that we expect in a modern state to be available to us to enforce the law. And therefore international law must not really be law because it's not actually enforced. And so the idea of outcasting is to say, well, you actually have to understand that the way in which international law is largely enforced is not through the kind of tools that the modern state uses, like police. It's through what we call outcasting. And outcasting is basically creating collective benefits that come from international membership in organizations, and then excluding states from the benefits of that membership if they violate the rules of the international legal order. And so the idea is basically, how do we punish you? We don't punish you by sending in, generally speaking, by sending in the military, although occasionally, obviously Security Council can authorize interventions under Chapter 7, but that doesn't happen very often. How do we then enforce international law? We enforce international law by taking away some of the benefits you get by being a member of the global community. And so you're seeing Russia being subject to huge amounts of outcasting right now, not just economic sanctions, but it's being kicked out of the Council of Europe. It was kicked out after Crimea out of the G8. It can't fly its planes over Europe or the United States. I mean, there's all these ways in which it's losing the benefits of being a member in good standing of the international legal order. And therefore, losing access to global markets, to global interaction, to global organizations, to all these things that it cares about. And the idea is that that's a way to motivate states to come into compliance with international law, because they actually want these things that come from being members in good standing of the international order. And when they lose them, they realize how valuable they are. And the idea is that that is a way in which you can enforce the law, is by taking away these things that they otherwise would be entitled to if they were members in good standing of the international order. And we're seeing this play out in the invasion of Russia into Ukraine by just seeing, Europe and the US and many other nations are kind of pulling out all the stops in denying Russia many access to many of the markets, many of the organizations that it has traditionally been a member of. And the problem with sanctions and problem with outcasting generally is that it doesn't have generally the satisfaction of immediately working. Right? It takes some time for the effects to set in. The threat of sanctions can sometimes be deterring, but obviously that didn't work in this instance. And so part of the difficulty is it takes some time before the costs set in, although the ruble has fallen, the Russian stock market hasn't opened because it'll certainly crash. I mean, there's a lot of immediate costs, but really the main costs are going to come down the line.
Thank you. Let's turn to you, GABOR. I want to talk a little bit about some human rights issues, some humanitarian issues. We've heard and seen so many pictures about the killing of civilians or the targeting of civilians. I'm sure many of the people on this call watched the video that Zelensky showed when he talked to Congress. We've heard reports about the shooting of people standing in a food line. More than 40 attacks have been reported on healthcare facilities, maternity wards and hospitals have been attacked. Reports of targeting children in particular and schools. The theater in Mariupol, they've estimated 700 deaths, 1,200 wounded, and the numbers just keep going up. ICC prosecutor Karim Khan has said he believes there is credible evidence of, quote, both alleged war crimes and crimes against humanity that have been committed in Ukraine, and has pledged to follow the applicable rules of international humanitarian law. What are the mechanisms he's referring to? How do you see this playing out? And can you give us a little bit of historical insight into how the Geneva Conventions speak to this moment and could be able to have some impact when it comes to addressing what's happening in Ukraine?
Thanks, Karen. Well, first, thank you for inviting me. I'm also honored to kind of share this program with OONA, who's been one of my go-to oracles on all matters of international law for a long time. So it's a real pleasure. I think I should start, since the program was titled War Crimes, Crimes Against Humanity, et cetera, with an explanation of a little bit of the difference between those categories, with OONA already having explained the crime of aggression. So war crimes, perhaps obvious, only happen in war. Whereas crimes against humanity and genocide, they can happen in an armed conflict, they can happen outside of an armed conflict. The substance of these areas of crimes can overlap. In other words, something that you do could be a war crime if it happens in war. It could also be a crime against humanity. It also could be genocide. But crimes against humanity, unlike war crimes, must be part of either a widespread or systematic attack on a civilian population. It has to be a big thing. War crimes don't have to be a big thing. It can be just one person doing one thing. And also, crimes against humanity, in addition to having to be widespread or systematic attacks on a civilian population, require acts also against individuals or groups. They may or may not amount to physical violence. For example, mass deportation, enforced disappearances. Those can all be crimes against humanity. They can also be war crimes if they're committed in an armed conflict. Likewise, genocide doesn't have to happen in war. It can happen outside of war. And I think, contrary to popular belief, although I'm sure most of the participants in this program understand this difference already, genocide isn't just another term for mass murder. Genocide is defined by various acts that are done with the intent to destroy in whole or part a particular ethnic, religious, or racial group. So the essence of the crime isn't, it's the targeting of individuals, not because of what they do, but because of who they are with the intent to destroy their group. And likewise, it doesn't have to be killing at all, let alone mass killing. For example, enforced sterilization could be a form of genocide. I want to talk just a little bit in more detail about war crimes, because I think in addition to the crime of aggression, war crimes are the most salient issue here. And I just want to give some historical background about war crimes, as well as there being, I guess, tension about whether or not international law is worth anything these days. It's always been a debate about the notion of war crimes as well as a subset of international law. And some people are fond of quoting, Cicero 2,000 years ago, who said that in war there is no law. I think he was wrong then, and he's a lot more wrong now. More recently, about 300 odd years ago, Rousseau in the Social Contract noted that the only permissible object of war is to disable enemy forces. That's a much more limited notion of what war is for, or what can be done in war, than the idea that there's no such thing as law in war. And from that limitation that Rousseau expressed, we get a number of law of war or law of armed conflict or international humanitarian laws. It's called principles. Let me just kind of outline a couple of them. One is the notion of military necessity, that you can only target those things that weaken the enemy's forces. Second is a principle of distinction. You have to distinguish not only between combatants and civilians, but also between military objectives and civilian objects. And you can only target the former and you can't target the latter. There's a principle of proportionality. And that means that although not all harm to civilians is illegal, we recognize the notion of collateral damage, in other words. But even collateral damage has limits to its permissibility. Civilian harm that is disproportionate to the military advantage that's expected to be gained in an attack is impermissible, and can also be a war crime, as can the direct targeting of civilians. And also in line with the protection of civilians is the principle of proportionality. So even if an attack is not disproportionate in how much it harms civilians, it could still be a violation of IHL. It could still be a war crime if the attacker has failed to take reasonable steps to minimize civilian harm in the advance of an attack. And the Geneva Conventions, to which every country on earth is a party, excuse me, I have to plug my power up. Yeah, every country is a party to the Geneva Conventions. And the Geneva Conventions take these principles and they articulate a large number of rules in connection with them. Some of those rules are war crimes, others are not. For example, the Geneva Conventions requires that prisoners of war be accorded musical instruments. The failure to do so is, not a war crime by most measures. But the Geneva Conventions also say that there is a subset of especially serious violations of the conventions that not only constitute war crimes, but that each state is actually obligated to prosecute. These are called grave breaches. Now, we could also now go on to talk about the various tribunals and the formats in which accountability can be accomplished in connection with these Geneva Convention requirements. OONA spoke about some of them, but I'll give it back to you to organize how we want to talk about the rest.
Yeah, so one thing I just want to ask you is, you talk about, crimes prior to war, crimes in war, I'm curious how the word war plays out here. I mean, I've noticed that in a number of contexts, particularly in the beginning of the invasion of Ukraine, there was a reluctance to use the word war. And I still see it, and they'll say the invasion, and I hear it, on television, I read it in people's pieces. So what makes a war a war? And why is there this fear about naming it war, at least, how you would explain that?
I think there's, on the one hand, a legal explication of that, and there's also a political one. Let me start with the legal. International lawyers don't talk so much about war as a legal term anymore. We speak of armed conflict. And that's partly because states are not so much in the habit of declaring war anymore. And we in international law want to make it very clear to everyone on planet Earth that the application of the laws of armed conflict do not depend whatsoever on the state's perception of whether or not it is at war. It depends on facts on the ground. And the facts on the ground that matter in the case of what we call international armed conflict, whereas it's state A against state B, is that it's a very low threshold of violence that is required. Anytime state A uses armed force in its relations with state B, that triggers the international law of international armed conflict. And it doesn't matter whether the states either do acknowledge or don't acknowledge that a state of war exists. As to on the political end, though, and I think probably everybody's familiar right now that with the notion that you can go to jail for 15 years in Russia if you say the word war. States often don't want to acknowledge the existence of war for a couple of reasons. For domestic consumption purposes, they don't want to promote the notion, or Putin doesn't want to promote the notion that he's taking action against Ukraine. He's acting for Ukraine. And he wants to minimize the appearance of hostilities as well. He may also want to deny the belligerent status that the enemy gains when the state of war is recognized. So it's kind of the avoidance of recognition, maybe similar to what we're familiar with in what the United Kingdom called its war in the conflict in Northern Ireland. They never said war; they said the Troubles. So there are both. There are political reasons why states want to avoid the term. There may be some legal reasons they want to avoid the term. And because of that, we in international law have pretty much let go of the notion that the terminology of war or not war is significant. What we're concerned about in the international context is simply the question of whether state A is or is not using force in its relations with state B.
That's actually kind of interesting because, given all the technology and the different kinds of combat, if you will, and in the world today, whether it's cyber or other things that are enabled technologically, it's sort of weird that we can use the word war still only for use of force, armed conflict, because even the use of force, I think, could be expanded, but I guess we can talk about that another time. But it brings me to another question, which is basically, the whole world is focused on Ukraine right now. And it seems like it's a particular moment in time where there are so many issues that are converging, legal and otherwise. Do you have any thoughts about why Ukraine has so taken over not just the interest of the world, but also the emotional investment of the world, and how that seems to relate to all this, including the focus on application of legal norms, regulations, and laws?
Yeah, that's on the surface that may seem an easy question to answer.
No, I gave
but
you
I think when you scratch the surface, it may get a little more difficult. There are, certainly, and I think legitimate observations that have been made that questions of race, questions of discrimination, and questions of kind of geographical discrimination explain why we're so much more up in arms about Russia in Ukraine than we have been about Russia in Syria, or about Myanmar, or about Mali, or about Yemen. And I don't want to minimize any of those criticisms, but nonetheless want to point out some important differences. The General Assembly passed a resolution condemning the Russian attack on Ukraine. It's the first time in the history of the United Nations that the General Assembly has noted and condemned a violation of this most fundamental aspect of the UN Charter, the prohibition of the use of force, in connection with one of the permanent members of the Security Council. And it's not because of that fact alone, but it's because of what is represented in the way of challenge to what we call the international rules-based order that is represented by a member of the P5 in the Security Council, engaged in such a momentous breach of the UN Charter. It is, I think, that separates the reasons for the extremely broad and deep and I should say shockingly immediate response of the international community to this violation from other atrocities committed in other conflicts. This represents an inflection point for that international rules-based order that many of these other conflicts, that many of these other atrocity situations, as horrific as they are, do not represent. And I think the fact that it is happening in Europe instead of Asia, Europe instead of Africa, are of course relevant, but there are also some, I think, less odious reasons for the difference between the reaction to those and the reaction to this.
Yeah, and I want to turn to you just for a little bit on that same question, which is that, maybe we've been hearing about, we're in the age of great power rivalries, right? We're leaving the non-state actor context of terrorism behind us. And so I'm wondering how much of this, from your point of view, has to do with Russia itself. And a couple of things about that. One, Russia being on the Security Council, which you mentioned before. And is that another reason there's been these other, recognizing how that might tie our hands? Is that kind of give some power to these other organizations to sort of say, we have to step in here about that? So that's the first thing. And also just a sense of, you and others have written about Russia sort of getting away with a lot of things in the past, whether it's Crimea and the annexation, whether it's cyber attacks around the world, whether it's interference with elections. But do you see this? Is there a way to use international law? Do you see ways in which people who represent the international order of things think maybe we should have pushed harder on using international law earlier when it comes to Russia and maybe others?
Yeah, great. I mean, all of this I think is really important. So I think I want to take a little bit of a step back, and I think that part of what's going on here is exactly as GABOR said, is this is seen as such a fundamental threat to the international legal order in a deep and kind of unambiguous way. There's no kind of argument that one can make, although Putin tried, but the argument was so laughable from the get-go that there just wasn't even a remotest basis for justification for this violation, which was just such a bare violation of really what is the fundamental bedrock principle of the modern international legal order. And I think that's part of what has been what has brought out this visceral reaction from so many. And I'll just say, to contextualize this, I think that we have had this tendency a bit to take that for granted. And part of the reason that Scott Shapiro and I wrote the book that we did called The Internationalist, which is really about the decision to outlaw war in 1928 and then reaffirm that in 45, was to say, you know, this is actually sort of new. Like the world used to be a world in which war was legal and legitimate. Hugo Grotius, the father of international law, if you actually read him, his idea of a just war was a war waged for legally cognizable reasons, which could include things like collecting debts, or you stole my wife, or, you know, you're interfering with my trade relations, or, you know, you're messing with my inheritance rights. Like those were all legal and legitimate reasons for going to war. Or I'm worried about the fact that you've got an alliance with other powerful states that I worry are going to come after me. And so I'm going to wage a war against you because I'm afraid of future threats that might pose. So balance of power arguments were rife and common during this era. And so what's so striking about this is I think in some ways, we kind of been lulled into kind of sense of complacency, at least in the West, that, you know, this is how it's always been and this is how it will always be, you know, and that we don't have to worry about this anymore. And in a way, the decision of Russia to invade Ukraine without any kind of veneer of legality, it just kind of rips off those blinders and makes us realize, wait a minute, like this legal order is incredibly fragile. Now, should we have realized that earlier? Absolutely. Absolutely, we should have. And in fact, the United States and the UK and France are responsible for having really stretched the bounds of the international legal order in the last several decades, developing a very expansive and I think indefensible interpretation of the right of self-defense, which has been used to justify all kinds of wars abroad in ways that I think are not permissible. Should we have stood up to Russia earlier? Absolutely, we should have. The difficulty, I think, particularly in Syria, was that Russia wasn't violating this Article 2.4 prohibition because Assad had given permission to Russia to use force. And in fact, Russia was using force to hold up the Assad regime. And so it was a violation of, you know, international humanitarian law rife and human rights law rife throughout Syria, but it wasn't a violation of this core norm of international law, the prohibition on use of force in the same way. So, I mean, the one hopeful piece of all of this is that this is, in a sense, is a wake-up call. And it's woken up a lot of international institutions. I mean, the ICJ acted with unparalleled speed in coming down with a decision on Monday after having heard, or on Wednesday after having heard arguments just a few days earlier. So it has moved incredibly quickly. The prosecutor of the ICC has moved incredibly quickly. And there's a great deal of consensus, and we had 141 members of the General Assembly condemning the General Assembly, which is, as was said, you know, really an unprecedented fact. And you know, the Uniting for Peace resolution being used, kind of, that had fallen into complete dormancy. Nobody had really used it, and that's what led to the General Assembly vote, because after Russia vetoed the Security Council resolution, then the Security Council, acting under the Uniting for Peace resolution, which doesn't allow for a veto by one of the P5 members, referred the matter to the General Assembly. And that's what led to this kind of unprecedented vote in the General Assembly. So there's all these new things kind of coming out of the woodworks in a way that, you know, could revive these legal tools. It's sad that it might have taken this to do that. It could also, you know, if this all goes bad, delegitimize the whole system. And you know, so it's not clear necessarily which way this is going to break just yet. But there are sort of some hopeful notes there as I see it.
I want to start looking at some of the questions because we're getting a lot of them, and I'd like to get as many as possible. So I'll start with this one. The US is very publicly making clear that they are avoiding going to war with Russia. Who has standing to file charges of war crimes? Does it have to be the victim? I think the question becomes, could it also be a prosecutor? I mean, how does that play out? Gabor, you want to take the first shot at that?
Yeah, I'm going to guess that question comes from outside the United States. Because within the United States, we're not accustomed to the notion of victims pressing criminal charges. The International Criminal Court And I'm going to transform the question a little bit into, how do prosecutions commence rather than whether the victim can. In the International Criminal Court, the prosecutor can seek to commence an investigation, and a pretrial chamber has to approve that. The prosecutor did do that almost immediately, and as soon as he did, some 30-odd states have also taken a separate route toward starting an ICC investigation, which does not require the approval of a pretrial chamber. They just filed an application to do so with the International Criminal Court, and so it happens. So in the International Criminal Court, investigations are commenced by virtue of the powers of the prosecutor or by virtue of the states that are parties to the Rome Statute for the International Criminal Court that can make a referral to the court. And both of those things have happened. But let's not forget domestic law. Domestic law is where 99% of the action really is in the enforcement of even international law. As I said, every country on earth is a party to the Geneva Conventions. Therefore, every country on earth has an obligation to enforce the war crimes provisions that the Geneva Conventions say they are required to enforce. We have a war crimes law. Unfortunately, our war crimes law does not comply with the requirements of the Geneva Conventions to exercise universal jurisdiction. And that's one area in which we, the United States, and many other states, could improve their compliance with international law. That would enable countries themselves, whether or not they are the territory on which the crimes were committed, whether or not they are the country of the nationality of the person who committed the crime or the nationality of the victim of the crime. In other words, some war crimes are so egregious that international law requires the exercise of universal jurisdiction, meaning you have to search for this person if they're suspected of being on your territory. If you find them, you have to prosecute them. If you don't prosecute them, you have to extradite them to someplace that they will be prosecuted. Our war crimes law is not that expansive. It needs to be amended in order to comply with the Geneva Convention obligations. Other ways that that prosecutions can be commenced, and a number of authorities have now alluded to the fact that, well, and as OONA said, the Security Council isn't going to establish a tribunal because of the Russian veto, but now questions are starting to be raised, and there are some precedents for the General Assembly, especially if it's with the consent of Ukraine, establishing a tribunal for the purpose of trying the crime of aggression, which, as OONA said, cannot be tried by the ICC. So the ICC prosecutor, the various states that are parties to the International Criminal Court Treaty, national governments in the operation of their own domestic law, and now also the General Assembly could take a role in commencing prosecutions by standing up what we would call an ad hoc tribunal that is in cooperation with Ukraine. Of course, there's also still potentially the Nuremberg model. A lot of us think that's probably not such a good idea for states to simply establish a tribunal without the backing of international institutions like the ICC or like the General Assembly, but that's conceivably another way that prosecutions can be commenced.
One question I want to turn to you, OONA. An audience member who'd like to know what could happen with the legally binding order issued by the ICJ requiring Russia to suspend any use of force in Ukraine. Is there any, gets back to what bite is there to these things? What is it?
Yeah, it's a great question. So narrowly speaking, what are the options for actually enforcing the ICJ order, which basically orders Russia to stop its invasion? what happens if it doesn't do that? Unfortunately, the way that the ICJ statute is set up is that if there's non-compliance with an order of the ICJ, then there's referral to the Security Council, which is the body that then can take measures to enforce it. And again, as we've talked about, Russia has a veto there. And so the likelihood of, for instance, authorizing the use of force to enforce it is highly unlikely. Though I will just point out the inability of the Security Council to act under Chapter 7 here is actually not the thing that's preventing states from coming to Ukraine's defense through use of military force, because they could do that under the UN Charter, under Article 51, collective self-defense of Ukraine. What is stopping them instead is fear of nuclear Armageddon and World War III. So that's not actually the thing that's stopping it. So then does it mean that this is kind of worthless and it's not worth, what the paper that it's written on? I don't think so. I think it's actually very powerful because it cuts off the arguments that the Russians are trying to make for what their justification is for their intervention. And so Putin is saying to his own people, and he's trying to argue to the international community, like, I had to do this. Like, I was coming to the rescue of the people in Eastern Ukraine. Like, this is a justified military intervention or special military operation, I guess he's calling it, to rescue these, people who are being subject to violations by the Ukrainian government. And what the ICJ decision does is it basically calls him on his bluff. And it says, you know what, those are actually not legal arguments that you're making. There's no justification and you have to stop. And I think that makes it harder for China to provide support to Russia. It makes the argument that Russia might make to seek military assistance from China in particular much weaker. So I think it has real consequences. I think it also hardens the resolve of states that are allied against Russia, whose view is that what it's doing is clearly illegal. You've got an ICJ decision really backing that up. So it has consequence, but it's not going to have consequence in the sense that, like, you have a court order in the United States, you win, and then you can get the police to go enforce it. And if you refuse to, then there's a contempt order and they throw you in jail. Like, nothing like that is going to happen. But that doesn't mean that it's meaningless. That's, I think, the important thing to remember.
Karen, can I butt in here for just a sec?
Of course, please.
So I think there's been a fair amount of confusion about the difference between the law of neutrality and the law of self-defense and how they do or don't interact. I think it's important to bear in mind that if a country comes to the assistance of another country in this conflict in a certain material way, that may destroy its protection from attack under the laws of neutrality. But losing your neutrality doesn't mean you're violating international law. The law of self-defense, as OONA said, is you're allowed to defend yourself, and states are allowed to engage in collective self-defense as well. So if a state comes to the aid of one side or the other, well, they very well might become a party to this armed conflict, which has significant legal ramifications. But whether that's a violation of international law is a separate question. Now, in connection with the negotiations that are now going on and being made public about between the US and China, the question arises, well, we're telling China to stay out while we are not staying out. We're supplying material assistance. Well, the basic difference, I think, has to do with what OONA was saying about the law of aggression. If China materially assists Russia, then it could be also seen as participating in the violation of the prohibitions of the UN Charter against aggression. It's not that they're not permitted to come to the aid of a country in the way of self-defense, and that's the big difference between the prospective involvement of China in support of Russia and the actual involvement of Western and other countries in supporting Ukraine.
OONA, you've written about this, expanding the idea of, who's allied on one side and who's the other, and you've talked, the doctrine of state responsibility. So I'd like you to talk a little bit about that, but also I just want to bring in, what's the coordination between legal efforts of all the kinds we're talking about across the spectrum and diplomacy? Because, in a way, what you're really trying to get at is stopping the use of force, right? Not just who can we punish afterwards. And so to what extent, and I want to ask both of you this question, but let's start with OONA here, which is, what is the interface with diplomacy, and how is that working so that everybody's kind of on the same page, working towards the same goal?
So I think that that's a really important insight about the role that law plays in a conflict like this. So one of the key roles that law can play, that international law can play, is setting a set of kind of shared expectations for behavior by states and a set of rules that everybody has agreed to abide by. And then agreement that when those rules are violated, that there are going to be some consequences. And I think that from the outset of this conflict, what you've seen is that when states are responding to Russia's action, they're describing their response, they're motivating and explaining and justifying their response by reference to international law. So they're putting in place sanctions, they're saying, we're doing this because this is a clear violation of Article 2.4. When they're acting, they're explaining, we're cutting off airspace for Russian aircraft because they're violating the UN Charter and they're waging an aggressive war in Ukraine. They're using that language. It also is language that can be used to dissuade states from assisting Russia. So an article that Ryan Goodman and I posted yesterday on Just Security makes the argument that China could be responsible under the doctrine of state responsibility for some of the illegal actions that Russia is undertaking in the war if it provides military arms to Russia, because under the doctrine of state responsibility, if a state aids and assists another state in committing an internationally wrongful act, and it's acted and does so knowingly, it can be held itself responsible for the illegality of that action. And so in this instance, that would be both responsibility for the waging of an aggressive war and responsibility for the massive international humanitarian law violations that are taking place, and that China could be held responsible for that if it provides military assistance, weapons, arms, other kinds of assistance to Russia. And we've had that translated in Chinese in particular, because we want a message to China and to ordinary citizens within China and anybody who might be listening, that this is very dangerous for you to provide this assistance to Russia, because if you do so, potentially could open up sanctions being levied against China as well. And that's got to be part of the diplomatic conversation as well. There's a conversation between Xi and Biden today. I'm sure that is part of the argument that's being made, is that Russia is engaging in a massive violation of the international legal order, both through waging an aggressive war and through violating the Geneva Conventions openly, through wantonly killing civilians. And that if China provides support to Russia, that it's responsible for that. And it could be held responsible for it, but it also is responsible for kind of undermining a stable international legal order. And while China might not always be on our side on everything, I think they generally are in favor of stability within the international legal order, and the incredible instability that this challenge to kind of fundamental underpinnings of the international legal order that this invasion represents is something that I think China should recognize, I hope will recognize, is not good for business, not good for China, not good for the world. And so it plays an important role in structuring states' responses to the actions, and in arranging for collaborative and cooperative reactions to the illegal actions. And it plays a role in making arguments at the diplomatic level about how states should and shouldn't behave in response to the behavior of a state that's so openly breaking the most fundamental rules of the system.
Yeah, I mean, one of the things that Putin's made really clear is that he rejects the international order the way it's being defined here today, and that part of what he's doing with the aggression in Ukraine is manifesting his ambition to change what the rules and regulations and the order of the world as we understand it is.
Yeah,
So,
do you mind if I say something about that? Because I think that's such an important observation.
Please do.
Yeah, I mean, I have been just struck again and again by how much Putin is a creature of what Scott Shapiro and I call the old world order. So that is the order that existed before the rules changed, that war was outlawed as a legal and legitimate way of enforcing the law. I mean, the things that he is saying are things that would have made sense 100 years ago. These are, that that economic sanctions are equivalent to a declaration of war. That would have been true 100 years ago. That is not true today. Merely providing economic support to a belligerent that is, in this case, defending itself against an illegal war is not an act of war and is not equivalent to declaring war. It's perfectly legal and legitimate, and it doesn't make them parties to a conflict. And so again and again, he's saying things that sound so much like he doesn't realize how much has changed. I mean, he really is living in a world order of 100, 150 years ago. Mm-hmm. And in a way, that's part of what makes this such a stark contrast between Ukraine, which has been fighting the war in a way, in the courtrooms and using law again and again and again. It's kind of putting itself as a defender of the modern international legal system, talks about sort of being defender of the values of Europe. I think that's one way of talking about like defending the very idea that we live in an international order where states can't just resort to force because they don't like what other states are doing. And I think that's kind of what's raised the stakes of this conflict in a way, is that each side is articulating a set of views that are really antithetical about what the international legal order is, and that Putin's aspirations do seem to be to really challenge some of those basic preconceptions that we all have about what the modern international legal order should be. And I think that's why the stakes of this are so high.
Yeah, you anticipated my next question, which was basically how high are the stakes and what are the stakes? Gabor, you want to add something to that?
I want to bring that back to China. I hope that part of the conversation between Biden and Xi today was about the extent to which these seismic shifts in the international legal order that OONA has been talking about and that have taken place over the last 100 years, and particularly since the Second World War. I don't think it's a coincidence that the world has become a less violent and more healthy and more egalitarian and a more humane place in those years. And that, China's kind of economic rise as opposed to Russia's stagnation, I think is a great deal influenced by the difference between how Russia and China relate to that international legal order. In other words, I hope Biden told Xi that essentially what Obama told the nation when he said to the Republicans, "You didn't build this, government built this," talking about roads and infrastructure, et cetera. And I think and hope that President Xi is mindful of the extent to which this international legal order is in great part responsible for the economic and social progress that China has made. And he recognizes that the continued kind of the continuation of that and China living in peace and security is dependent on the continuity of that international legal order. Now, with the rising tide of authoritarianism in the world, I suppose things could go one way or the other. But since I do think that so much human progress has been tied to the development and continued existence of this international legal order, I tend to be more optimistic than pessimistic that at least China, which can exert a very significant thumb on the scale of which way we go from here, hopefully will go the right way.
So what starts in one place expands to the globe very, very quickly, which is no surprise, I guess, in the age of COVID. So we are out of time. I have to say, I'm going away with even more questions than I knew I had. Among them, really, what is the legacy of the Cold War in terms of integrating kind of a mindset about the globe? And I just, something I think that this conversation makes you think about, in addition to things that happened 100 and 150 years ago in that mindset, but it might have some new questions about the Cold War. Before I thank you, I want to remind our audience that we have a screening of Alex Gibney's Forever Prisoner on March 28th in the evening, an actual in-person event, our first in a very long time. And Alex will be there and we'll have a Q&A afterwards. So I want to thank both of you, OONA and GABOR. This was a fantastic conversation. You both have the ability to both give a primer to people who are not experts in the field and to talk about the larger issues that resonate with all of us in a way that we just come away so enriched and thankful. And so we are grateful. Thank you so much. And we'll see you again sometime.
Thanks so much
Thank
for
you.
having us.